So Donald Trump is not happy about Jack Smith's moves at the appellate level as well as in the Supreme Court. Welcome to Law and Society. Let's talk about that. So, what had happened was there is the substantive case that is at Judge Tanya Chutkan's court, which is for conspiracy to defraud the United States, conspiracy to obstruct official proceeding, obstruction or attempted obstruction of official proceeding, and deprivation of rights under color of law. So that is the substantive case. And what we are right now in the middle of is the pretrial procedures in which Donald Trump is bringing up one motion to dismiss after another. So, what uh, happened with the first one of the things that Donald appealed was the gag order, and the appellate circuit reinstated the gag order. Then the appellate circuit accepted the appeal from Judge Tanya Chutkan's order that denied the motion to dismiss on governmental immunity grounds. Donald Trump appealed that order to the DC Circuit. What Jack Smith has done, now we are now moved from the substantive case into an interlocutory, meaning an intermediary appeal in the middle of the case, which is of an important issue that, if not resolved now, would be outcome determinative at the end. If the whole case went forward all the way to the end, and then the court ruled that there was no governmental immunity, it would just, it would do away with all of that time. And in the interest of time, if nothing else, for the appeal to move forward. Now, Donald Trump appealed the governmental immunity appeal here, and then Jack Smith moved in the DC Circuit Appellate Court to expedite that. And at the same time as he did that, he moved and petitioned the Supreme Court to assess whether it would grant certiorari, meaning grant a hearing on the substance of the case, which being governmental immunity. Not the substance of the case that is scheduled to be on trial on March 4th, mind you. That's what Donald Trump is trying to delay. Now, with this movement by Jack Smith, what he has done is essentially undercutting Donald Trump's delay strategy. Donald Trump wanted to use the appellate process to delay the case, the March 4th substantive case, as much as he possibly could, indefinitely, if it were up to him. Now, that is no longer possible because Jack Smith has moved to expedite, and the DC Circuit has agreed to expedite and come up with a very expedited schedule where the last filing will be by the end of the 2nd of January. And the Supreme Court has agreed to hear whether they will hear the governmental immunity case and ask Donald Trump to respond to Jack Smith's petition to hear the governmental immunity case. So it's still one step removed from whether the Supreme Court will hear the governmental immunity issue or not. And because of the governmental immunity case that is now in the circuit and in the hands of the Supreme Court, there is a stay on all matters that is ongoing in the substantive case, meaning the discovery process and everything has been put on hold. And so every day that the appellate court delays after hearing the case in the appellate court's docket, that would be mid-January, I would think. And for Supreme Court, it would be the end of this year or early next year. And I would think that after being warned, after being notified by Jack Smith that this time is of the essence in this interlocutory appeal of government immunity, that the appellate court and the Supreme Court would understand the urgency of it. Now, uh, one other thing that I wanted to touch upon, there's a case that the Supreme Court has granted certiorari on already, meaning it will hear the case, and that is on the charge of obstruction of an attempted obstruction of official proceeding. And the issue at hand there is whether tampering is a necessary element to prove in the statute. I think it's 1512 section C. And that a lot of people have said it's ominous to Donald Trump's case that is there for conspiracy. But as I said earlier on, Donald Trump has been indicted for 4 felonies over there: conspiracy to defraud, conspiracy to obstruct official proceeding, obstruction or attempted obstruction of official proceeding, and deprivation of rights under color of law. And even if the Supreme Court says that, yes, witness tampering is an element of obstruction that the government didn't prove, maybe that charge would go away from Donald's case, because even that's not assured, because the circumstances are different in Donald's case with obstruction. But even if that went away, the other charges would remain. So that's about the substantive case of Donald Trump, and not the interlocutory case, which is the intermediary case of governmental immunity. So keep the March 4th, 2024 date in mind, and expect to see appellate court, DC Circuit, and Supreme Court movement at the end of this year, and if not, early January. And I would hope that by the end of January, the governmental immunity issue will be resolved. Wouldn't be surprised if Donald Trump comes up with more motions and brings up more interlocutory cases to stop the main trial date. That is very likely. So as it seems now, March is still the trial date, unless something is delayed by the appellate circuit, or if the appellate circuit and the Supreme Court decide to take up more interlocutory appeals that Donald moves up simply for the purpose of delay. So with that, I'll end this quick rehashing. I wanted to come out and do another one because I felt that the previous video that I did wasn't concise and wasn't pointed enough to be able to explain. So I hope that I've explained the issue and we explained the case, and then the other segment that is now going up on appeal. If you have any questions, please leave them in the comment box. And if not, please share, like, and subscribe. Thank you very much.